Hey guys, welcome back to my YouTube channel CMA Club. Myself Vaibhavi Thakur, and today I am going to start with the second lecture of Indian Contract Act 1872. I am posting this video too late because I was not well and I am sorry for that, but from now onwards I will post the videos regularly so that you can follow it. So, in the last class, we have done till revocation of acceptance. Now we are going to start with the void agreements. So the void agreements are the agreements which are not acceptable by law. Okay. So these are some cases which of void agreements. So the first one is considerations and objects unlawful in part, section 24. So what does this say? If any part of a single consideration for one or more objects, or any one or any part of one of several considerations for a single object is unlawful, the agreement is void. So after reading this makes a little bit of confusion, but I'm making it simple. So if any part of a single consideration for one or more objects, so a part of a consideration is unlawful, then the agreement is said to be void. And if any part of several considerations or one of several consideration is unlawful for a single object, then also the agreement is said to be void. Okay? Agreement without consideration, section 25. So any agreement without consideration is considered as void, but there are some exceptional cases where the agreement without consideration is also acceptable. So what are they? The first one is it is in the writing and registered. If it is written and registered, then the agreement without consideration is also acceptable. So it is expressed in writing and registered under the law for the time being in force for the registration of the documents, and is made on account of natural love and affection between the parties standing in a near relation to each other. So if there is a relation of natural love and affection between the parties and it is in a near relation to each other without consideration, then the agreement is acceptable. If is a promise to compensate for something done. So if someone has made promise, if is a promise to compensate for something done, if some person has done something for the someone, so for compensation, if there is an agreement and there is no consideration involved, then it is acceptable. It is a promise to pay a debt bare by limitation of law. If there is any debt to be paid by one person to another and no consideration is involved, then also it is acceptable. So agreement, the next one is the agreement in restraint of marriage, section 26. So what does this say? This says that every agreement in restraint of marriage of any person other than a minor is void. Okay? So if there is any agreement in restraint of marriage of any person other than a minor, if their minor is there, then it is not void. Other than a minor, the agreement will be void. So the next one is agreement in restraint of trade, section 27. Every agreement by which anyone is restrained from exercising a lawful possession, trade or business of any kind is to that extent void. So what does this say? It says that if there is any person who is exercising unlawful act or who is doing unlawful trade or business, then the agreement is said to be void. There is an exception in this case also, which is saving of an agreement not to carry on business of which the goodwill is sold. So this is an exception for this case. The agreement in restraint of legal proceedings, section 28. So what does this section say? Every agreement by which any party is restricted absolutely from enforcing his rights under or in respect of any contract by the legal proceedings in the ordinary tribunals or within such time limit to enforce his rights. So if there is any party who is restricted absolutely from enforcing his rights in a contract within a specified time limit, then the agreement is said to be void if it is done by that person, which destroys the right of any party or discharges any party from any liability under or in respect of any contract on expiry of the specified period so as to restrict any party from enforcing his rights is void to that extent. So what does this say? That if any party discharges any party from any liability or destroys the right of any party means the person, okay, under or respect of any contract on expiry of the specified period or restricts the party from enforcing his rights, okay, doesn't allow to enforce his rights, then the agreement is said to be void. But there are some exceptions. What are they? Saving of a contract to refer to arbitration dispute that may arise, saving of a contract to refer questions that have already arisen, and saving of a guarantee agreement of a bank or a financial institution. So these are the exceptions of this case in agreement in restraint of legal proceedings. Okay, the next is agreement void for uncertainty. Uncertainty means the things are not certain, section 29. So the meaning of which is not certain or capable of being made certain are void. So the agreements, the meaning of which is not certain, which is uncertain, or the agreement which is not capable of being made, okay, so these are not certain, are void. Agreement by way of wager. Wager means betting, section 30. Agreement by way of wager are void. So the agreements by way of betting are void, they are not acceptable by law. And no suit shall be brought for recovering anything alleged to be won on any wager. So you cannot suit against recovering anything from the wager or entrust it to any person to abide the result of any game or other uncertain event on which any wager is made. Okay, so if there is a case of a wager, means a case of a betting in which the result is uncertain, right? In case of a game, the result is uncertain. So in that case, the agreement is said to be void and you cannot file suit against anything or you cannot recover anything if you face any loss. Why? Because it is not acceptable by law. Okay, there is an exception in this case, which is exception in favor of certain prizes for horse racing. So this is an exception for this agreement by way of wager. So we have completed the void agreements. There are 7 sections in this case. Section 24, that is consideration and objects unlawful in part. Section 25, agreement without consideration. Section 26, agreement in restraint of marriage. Section 27, that is agreement in restraint of trade. Section 28, agreement in restraint of legal proceedings. Section 29, agreement void for uncertainty. And section 30, agreement by way of wager. It is very important to remember the sections. I will not say that the sections are not important. It is important. You have to remember each and every section of everything, and you have to write proper section and the right section in the exam. Otherwise you will not get marks. Please don't write the wrong sections. If you remember the sections at the time of examination, only then you write. Otherwise don't write, because it gives a negative impression to the person who is checking your paper. Okay, so, and if you will give the sections, it will give the good effect and you will get the good marks. So try to remember the section from the beginning only. Okay, and it is not that stuff. If you will remember from the beginning only, then you will not face any problem. You will remember each and every section every time. Okay, so the next topic is consideration. We did it in the last class. What is consideration we know, still we will read it. As per section 2 subsection D, consideration is defined as when at the desire of the promisor, the promisee or any other person has done or abstained from doing, or does or abstains from doing, or promises to do or abstain from doing something, such act or abstentions or promise is called as a consideration for the promise. Consideration is an essential for every contract. Obviously without consideration the contract is said to be void. So it is an essential element of the contract. So consideration is nothing but the desire of a promisor, the promisee or any other person who has done or abstained from doing, or does or abstains from doing, or promises to do. So it is in the, they maybe have done already, or maybe doing, or maybe will do. Okay, so this is called a consideration. Consideration in simpler terms I would say money. It is nothing but a money. Okay, now there are some fundamental principles for the consideration. What are they? Consideration must be at the desire of the promisor. So obviously consider must be at the desire of the promisor. The promisor, who is a promisor? The person who makes the proposal is called a promisor. Okay, when the proposal is accepted, it becomes a promise. Then the person who has made the proposal called the promisor, and the person to whom the proposal is made is called the promisee. So the consideration may move from the promisee or any other person. So it can move from one person to another. That doesn't matter. Now there are some types of consideration: executory or future consideration, executed or present consideration, and past consideration. So what is executory or future consideration? Now this is, it means that it makes the form of a promise to be performed in the future. So it is a promise to be performed in the future, as the word also suggests. The next is executed or present. So it is an act or a forbearance made or suffered for a promise. So it is an act for a promise. It is at present. The next is past. Past means a past act or a forbearance, that is to say that an act constituting the consideration took place and is complete before the promise is made. So the consideration is complete before the promise is made. So that is called a past consideration. So from the words itself we can identify what is that. Okay. Now the next topic is no consideration, no contract. We earlier did this thing, that without consideration the contract is said to be void. Section 25 defines this thing. Okay, so the general rule is ex nudo pacto, non-orator action. What does this line mean? This means that an agreement made without consideration is void. So any agreement which is made without consideration is considered as void. It is not acceptable by law. Okay, but there are certain exceptions to this. We did this thing in the earlier in case of void agreements. Okay, we did the exceptions. Now we will do this same thing. It is same thing. Promise made on account of natural love and affection. Obviously, if there is any promise made on account of natural love and affection, then even if it is without consideration, it is acceptable. The next is promise to compensate for the voluntary services. Obviously, we did the same thing. If there is any compensation to be paid, if any person has provided any service and he have to pay for something, then even if it is without consideration, it is acceptable by law. Promise made to pay a time bearer debt. If any debt is to be paid, then that is, if it is without consideration, it is acceptable by law. Then gifts actually made, creation of agency, charitable subscription, this all are allowed. Okay, these are not void agreements. These are exceptional for this. So it is acceptable by law, even if it is without consideration. Okay, so the consideration thing is done. We learned what is consideration. We did the principles for the consideration. We did the types of consideration. And we did the topic no consideration, no contract. And its exceptions. So you have to remember the concept of each and everything and not the word by word things. Why? Because in the examination you will get the case study of it. You will not get the direct questions. Okay, you will not get the direct question that write the note of no consideration, no contract, and you have to write this. No, you will get a situation in which you have to explain these things also, and according to the situation you have to explain your answer. Okay, so for that you need to understand each and every concept very clearly, and you have to remember it also. Okay, I hope till now you have understood everything. If you have any doubt regarding any topic, then you can comment me in the comment box. I will definitely try to answer you. Okay, now move on to next topic, that is stranger to the contract or doctrine of privity of the contract. So what does this say? Doctrine of privity of contract. It means that a contract is between the parties only and no third person can sue upon it. So no third person involvement is allowed in this case. The parties who are involved, they can sue each other, but the third person is not allowed. It means a stranger to the contract cannot sue upon it. Okay, so the third person is not allowed. But there are some cases where the stranger to the contract can also sue upon it. So in the following cases, a stranger to the contract can sue. So what are they? Beneficiaries under the trust or a charge. If there is any beneficiaries under a trust or in a charge, then they can sue. Marriage settlement, partition or other family arrangements. So if there is any marriage settlement or a partition of a family or any other family arrangement, then the stranger can involve. Acknowledgement or estoppel. Agency. If there is a case of agent, okay, where the agent is involved, in that case also the stranger can sue. Then assignee in case of insurance policy. So in case of insurance policy, assignee can sue. Okay, I hope you understood what is doctrine of privity of contract. It is a very easy concept. I hope you understood that. The next topic is legality of the object, section 23. So what does this say? The object of the contract is the ultimate purpose which the contract subserves. So the main purpose and the object of the contract is consideration. Now see, in the contract, the subject matter or the agreement is its object. So what is the main object? The subject matter. Why the contract is being done? The main thing is the subject matter or the agreement. Section 23 discusses about the legality of the object or a consideration. So what does section 23 discusses? It discusses about the legality of the object, what is legal, or the consideration. Okay, the consideration is an essential to the contract. It is a main thing for any contract. So the next is, the said section provides that a consideration or the object of an agreement is lawful unless, so the object of the object or a consideration of an agreement is lawful unless these are certain cases where it is unlawful. What is that? It is forbidden by law. If it is forbidden by law, then it is unlawful. Is of such nature that if permitted, it would defeat the provisions of the law. If it is permitted, if the permission is granted, then it will defeat the provision of any law. So it is unlawful. Is fraudulent. If it is any fraud is involved or it is fraudulent, then it is unlawful. Obviously, it involves or implies injury to the person. If it involves or implies the injury to the person or a property of any other person of another, then it is unlawful. The court regards it as immoral. If the court says that it is immoral or it is opposed to public policy, even then it is unlawful. So in each of these cases, the consideration or object of an agreement is said to be void. So it is said to be unlawful, and unlawful is void. Okay, every agreement of which the object or the consideration is unlawful is void. So in each and every agreement, if the object or the consideration of the agreement is unlawful, which is not acceptable by law, then it is said to be void. Okay, I hope you understood what is legality of the object. The next thing is e-contracts. This is a very easy topic. E-contract means electronic contract. It is a paperless contracts in the electronic form. It is the change of the technology and the legal requirement which leads to the contract to be in the electronic form. So, by changing of the technology and the legal requirements, the contract is in the electronic form. It is a contract modeled, specified, executed and deployed by a software system. So, it is modeled and specified, executed by the software system. Conceptually, it is similar to the traditional commercial contract. So, the concept of the commercial contracts is the same. There is no difference. It is just that it is in the electronic form and it is a paperless. So, no paper things is involved. Okay. So, it is a very easy thing. Now, there are some basic elements of the e-contracts. There are some basic elements of the electronic contract. It is same as elements of the contract. If you will read it, you will definitely understand it. So, the first one is an offer is to be made. Obviously, an offer is to be made. Offer is to be accepted also. Otherwise, it is not called as an agreement. There shall be a lawful consideration. Obviously, unlawful consideration is considered as void agreement. There shall be an intention to create the legal relations. Okay, illegal relations are not allowed. The parties must be competent to the contract. Obviously, the parties must be capable of doing the contract. There must be free and genuine consent. The consent must be free and genuine. There should be no fraud involved in it. The object of the contract must be lawful. Obviously, we learn over here legality of the object must be legal and lawful. Unlawful is void. There must be certainty and possibility of the performance. Obviously, uncertainty is not considered as legal. Okay, it is not considered as lawful. It will be void. And there should be possibility of the performance. Performance should be possible. Impossible things are not acceptable. Okay, so we did the basic elements of e-contract. What is e-contract? I hope till now you understood. So now the next topic is who are competent to the contract. Section 11. So who are the persons who are capable of doing the contract? Every person is competent to the contract who is of the age of majority according to the law to which he is subject, and who is of a sound mind and is not disqualified from contracting by any law to which he is subject. So, if any person has attained the age of majority, is competent to the contract, the person who is of a sound mind is capable of doing the contract, and the person who is not disqualified from any law is capable of doing the contract. Okay, age of majority means above 18 years. Now there are following type of persons who are not competent to the contract. So these are the persons who are not competent to the contract. They are not capable of doing the contract. So the first one is minor. Here we did that the person who has attained the age of majority is competent. So obviously the person who has not attained the age of majority, that who is a minor, is not competent. As per Section 3 of Indian Majority Act 1875, every person in India is a minor if he has not attained the age of 18 years. So the person who has not attained the age of 18 years is said to be the minor and he is not competent to the contract. However, in case of a minor whose person or a property or a both of a guardian has been appointed under the Guardian and Wards Act 1890, or whose property is under the superintendence of any court of wards before he attains 18 of age, is 21 years. So his minority is 21 years. Otherwise it is 18 years. So basically the person who has not attained the age of 18 years is said to be minor and he is not competent to the contract. Now, there is a position of minors agreement and its effect thereof is as under. So this describes about the position of minors agreement and its effect. So now we will learn about that. So the first point is an agreement with the minor is void ab initio. So the agreement with minor is void. Ab initio means from the beginning. So the agreement with the minor is void from the beginning. It is not acceptable from the beginning only. The law of Stoffel doesn't apply against the minor. So, minor can always plead his minority despite the earlier misrepresenting to be the minor. Means he is not liable for any act. Okay? So, if he does any agreement, he can plead his minority. He can take the advantage of it because there is no liability on him. Doctrine of restitution doesn't apply against the minor. Okay? So what does this say? That in India the rule of restitution by the minor are similar to those found in English laws. The scope of restitution of a contract by the minor was examined by the Privy Council in Mohibiri case, when it is held that the restitution of money under Section 64 of Indian Contract Act cannot be granted under Section 65 because minor's agreement is not voidable but absolutely void ab initio. So it is not said as voidable, but it is said as void ab initio. It is void from the beginning only. Similarly, no relief can be granted under Section 65 because this section is applicable where the agreement is discovered to be void or a contract becomes void. So this is not, there is no relief granted under Section 65. Why? Because it is possible only for the void, and this agreement with the minor is void from the beginning only. Okay, so nothing can be done in this case. The next is no ratification on attainment of the majority. Ratification means approval or confirmation. Okay, a minor cannot confirm an agreement made by him during minority on attainment of majority. So the agreement which is done in case when he was minor, he cannot confirm that in case when he attains the majority. If he wants to ratify the agreement, a fresh agreement and a fresh consideration for a new agreement is required. Okay, so fresh one is required when he attains the majority. Contract beneficial to the minor. A minor is entitled to enforce a contract which is of some benefits to him. Minority is a personal privilege and a minor can take the advantage of it and he can bind others. So he can take the advantage because there is no liability, personal liability upon him. Okay. The next thing is minor as an agent. So a minor can be appointed as an agent. It is acceptable, but he is not personally liable for any of his acts. So that thing is a negative point for others. Minor's liability for necessities. If somebody has supplied a minor or his dependents with necessities, minor's property is liable, but minor personally is not liable. Minors cannot be adjourned insolvent. Obviously, the agreement with the agreement with the minor is void ab initio. It is void from the beginning only. So he cannot be adjourned as insolvent. When a minor and adults jointly enter into the contract with the other person, minor is not liable and a contract can be enforced against the major person. Obviously, minor is not liable, personally liable for anything, so it will be enforced against the major person only if there is an agreement between a minor and a major and an adult one. Okay. So I hope you understood the case of a minor, the position of minor. This is an important thing. This may be asked in the exam. Okay, it is an important one, but they will not ask directly, so you need to have the proper concept. They will ask in case study. The next is sound mind person. A person is said to be of a sound mind for the purpose of making a contract if at a time when he makes it, he is capable of understanding it and of performing a rational judgment as to its effect upon his interest. So what is sound mind person? Sound mind person means when the agreement is being done, when the contract is being done at a time, he is capable of understanding that contract and make a rational judgment regarding that. Okay, that is called the sound mind person. A person who is usually of unsound mind but occasionally of a sound mind may make a contract when he is of a sound mind. This is a bit of confusing thing, so I'm making you simpler. So when a person is usually of unsound mind, he is not of a sound mind, means he cannot make the rational judgment, he cannot understand usually, but occasionally. But when he is sound mind, means he is capable of understanding the contract. When the contract is done, then it is acceptable. Okay, a person who is usually of a sound mind means he is of a sound mind usually, generally, but occasionally of unsound mind, may not make a contract when he is of unsound mind. Obviously, at a time of making a contract, he is of unsound mind, occasionally of unsound mind. Okay, sometimes he becomes of unsound mind, but when the contract is being made, at that time he is unsound mind, then he cannot make the contract. In simpler terms, you just need to understand that when at a time of making a contract, if the person is of unsound mind, it is not acceptable. He cannot make that contract. But at the time of making a contract, if a person is of a sound mind, then it is acceptable. Okay, so you understood what is minor, what is sound mind person. Now we will discuss about other disqualified persons. The persons who are disqualified from entering into the contract due to certain other reasons, maybe from the legal, political or corporate status. So some persons are not allowed, they are disqualified, they are not qualified for making the contract. So they are not capable of doing the contract, they are not competent to the contract. Some of such categories of persons given below, which are disqualified persons. So what is that? First one is alien enemy. An agreement with the alien enemy is void. Okay, but agreement with an alien friend is perfectly valid and enforceable. So agreement with alien enemy is void, but agreement with the alien friend is enforceable and it is valid. Next, foreign sovereign and ambassadors. Foreign sovereigns and their representatives enjoy certain privileges and immunities in every country. They cannot enter into the contract except to their agents. So agents residing in India, if their agents are residing in, they are resident in the India, they can make the contract through their agents only. Otherwise it is not acceptable. The next is convicts. A convict cannot enter into a contract while he is under an imprisonment. If he is undergoing an imprisonment, then a convict cannot enter into the contract. Insolvent. An insolvent is one who is unable to discharge his liabilities and therefore has applied for being adjudged insolvent. So the person who cannot pay the money, how can they make a contract? Okay, so it is not acceptable. Company or a statutory bodies. A contract entered into by a corporate body or a statutory body will be valid only to the extent it is within its memorandum of association. If it is written in its MOA, that is memorandum of association, then only they can enter into the contract, otherwise they cannot enter into the contract. Okay, so till now I hope you understood. The next topics we will do in the next class. Okay, so I hope till now you have understood everything and I hope you liked my video. So please like, share and subscribe to my channel, and please share it to your friends so that it can be helpful to them also. Okay, so till now, bye bye.